Good morning, everybody. On behalf of the team here at ARAG and also the team at Stephensons today, a very, very warm welcome to you all to the second of our Talk to the Expert series. This one obviously focusing on care, and I do hope you are all keeping safe and well during this time. So here's the agenda. Obviously a very brief intro from me, and then we'll hand over to Laura, who's going to look after the approach to risk management in the care sector at the moment, and of course that being in line with CQC.
I'm Laura and I'm a partner in the regulatory team at Stephensons, so I specialise in health and social care regulation. I'm going to be looking at the various and most important stages of the CQC's inspection and enforcement procedures and how we manage the risk in these areas, particularly at the moment as we go through the pandemic. The CQC launched its emergency support framework on the 1st of May in response to the COVID-19 pandemic and the suspension of its inspection programme. The framework effectively sets out the CQC's approach to how they will continue to liaise with providers and managers in all health and social care settings and help them monitor the impact of the pandemic and identify any safety risks. It's not an inspection, the care home isn't rated, but it is in effect a type of performance assessment. It's done via a call between the manager and inspector on Microsoft Teams, and it isn't audio recorded, but a summary record will be issued after the call outlining their findings. So essentially there is a risk that whatever is said during that call will inform any judgments on their current compliance and any decisions in terms of enforcement action and future inspections. The summary record isn't classed as an inspection report. It doesn't have ratings in it and it's not published, so you can't challenge the accuracy of the record. But these documents are likely to be relevant moving forwards and will probably form the basis of evidence in enforcement proceedings, as well as being shared with other key stakeholders like local authorities and probably form part of inquests and other proceedings like that. If we just go on to the next slide now, the inspection programme started up again in August, but the main focus at the moment is on care homes where they consider there's a potential risk or concerns have been raised by external stakeholders. In light of the suspension that's been in place, there's likely now to be a backlog, so this is probably going to affect services that were rated inadequate or required improvement before the lockdown began, and they may struggle with satisfying their contracts with local authorities and other providers, and also with attracting new admissions to generate income and secure their financial stability. So to manage this risk, they may now want to consider making a request for an inspection if they need to, but they need to make sure that they're prepared for this if they are going to do that. We found that the CQC are increasingly as well making requests for information as part of the inspection process since the pandemic began, and we think this is a way of limiting the time at a service for an inspection or to avoid the need for an inspection altogether. Providers are not usually under any obligation to comply with these types of requests, but it's usually in their best interest to do so. And the CQC do have a power under Section 64 of the Health and Social Care Act 2008 to issue a statutory notice which legally requires providers to provide information, and failure to do so is a criminal offence in itself. There's usually quite strict and short deadlines for these types of notices, but in order to manage the risk, providers need to make sure they're using all reasonable endeavours to comply with these requests and to provide assurances to CQC just to mitigate the potential risk of them taking enforcement action, which is usually the reason why they're requesting that information to make a decision on whether they should. Following an inspection as well, providers will be given a draft inspection report, which a lot of people will be aware of, and they are given a period of 10 working days from receipt of the report to challenge the factual accuracy and completeness of the evidence on which the ratings within the report are based. This sort of challenge is not usually an insured event, but it's a vital stage and key to mitigating the risk of any potential proceedings down the line. Inspection findings are often the basis for a decision on whether any civil or criminal enforcement action should be taken, and whether a service should be restricted in any way. So, for example, prohibiting new admissions to a care home, which could then restrict income and cause financial concerns for that provider. A lot of providers don't usually want to challenge the CQC at this point for fear of it going any further, but that really is the entirely wrong course of action. If no challenge is made to a draft report and it's subsequently published, there's then a presumption that the contents of that report is entirely accurate. So there's no record that the provider has challenged any of the findings, and then that's then used as the basis for a decision on whether they should pursue any enforcement action, and then it becomes much more difficult for providers to dispute the need for enforcement action on the basis of unchallenged inspection findings. We also find that the CQC will usually issue a statutory enforcement notice, particularly where it's urgent, either before or at the same time as a draft report if there's some serious concerns within that report. And we've dealt with cases in the past where a successful factual accuracy challenge has led to the withdrawal of an enforcement notice as well as the report, and also they've ordered a complete re-inspection. So it's really important that providers are proactive at this stage in order to manage the risk and prevent things from escalating further. After a report is published, there's an option for a ratings review request, but that has to be done within 15 working days of publication. There's only one ground for requesting a review. There's a 500-word limit, and so prospects are usually less than 5%, but it is important to challenge for the same reasons as I've already mentioned. If we go on to the next slide now and we look at civil enforcement action, civil enforcement is usually considered by the CQC after an inspection, where there's been large-scale non-compliance identified or breaches of the fundamental standards. In recent years, I think the CQC have been issuing more and more statutory notices to cancel entire registrations or impose conditions. And we saw that from the statistics from the last annual report, and hopefully we'll get a better idea of that when the next annual report is released soon. But I expect that there will be a continued increase, particularly following this pandemic, in the issuance of notices to cancel registration. From what we've seen so far, some care homes and other care providers have struggled to keep up with their normal systems and procedures. So general recording and auditing processes in particular have suffered. The priority has been more on keeping the home COVID free as opposed to documentation, and you know some care homes have struggled with that. The same time frames to criminal enforcement notices apply, so you have warning notices with a 10 working day challenge period and notices of proposal with 28 days, as well as a 28-day appeal period for notices of decisions to the Care Standards Tribunal. For warning notices and notice of proposal, we have seen CQC being more willing to grant extensions for those challenges, which helps manage the risk a little bit if there's more time to prepare, but really providers need to be acting immediately when they receive something like that. With regards to appeals to the Care Standards Tribunal, we've not really seen any real delay to the hearing of these appeals. The Tribunal have been holding virtual hearings, but urgent cases have probably taken a little longer to list, so rather than the usual 2 weeks, we've seen them taking maybe 4 weeks to get to a hearing, but that only helps manage the risk at the moment because there's more time to prepare, particularly where care homes are still under a lot of pressure. I think if an inspector indicates that enforcement action is going to be taken, then providers need to be taking prompt remedial action to mitigate the risk of that enforcement and addressing any shortfalls as soon as they can. If a notice is issued, then the prospects of successfully challenging it within a short period will be greater if they're able to document any improvements made. So it's important that they keep a separate file of evidence to document any action that they have taken. If we go on to the next slide, this is the CQC have had the power to prosecute since 2015 when they took over responsibility from local authorities and the Health and Safety Executive. They have a wide range of criminal enforcement powers, and they include prosecution, fixed penalty notices and simple cautions. These powers are limited to registered providers and certain individuals who work for providers, so directors, managers and a company secretary, for example. Fixed penalty notices are usually issued for less serious offences, whereas a prosecution will usually be pursued for more serious offences, and they're usually closely linked to an inquest as well as civil enforcement, like the cancellation of registration or a restriction on admissions to a service. You'll often find that a prosecution arises out of a serious injury to a resident of a care home or where there's been a death. So that's why there's usually a link with other proceedings. Fixed penalty notices will usually be a fine of anywhere up to £4,000, whereas a prosecution in the magistrate's court can lead to an unlimited fine plus prosecution costs. So a lot of the recent cases have been tens, if not hundreds of thousands of pounds. So the aim with any criminal investigation is really to try and mitigate the risk of a prosecution in order to limit that liability to a much smaller amount, or to persuade the CQC just not to proceed with a prosecution or any form of enforcement whatsoever. If we go on to the next slide, you'll see that things that we really need to look out for and which indicate a criminal investigation are an invite to an interview under caution, a PACE disclosure notice, which usually has a requirement to make a written response under caution, so as if you were at an interview under caution, and a suspected criminal offence letter. Interviews under caution are more difficult at present with social distancing measures, so we expect to see CQC invite more people to make written responses under caution instead. The risk here is that providers don't always appreciate that they are under caution, and so could potentially prejudice their own position or incriminate themselves unnecessarily. So it's vital that they receive legal advice before responding, if at all at this point, because as I've already demonstrated, the potential liability of a prosecution is quite significant. The response timeframes to disclosure notice can also vary from case to case, so it's important and vital that providers don't feel forced or coerced into making a response. If there's insufficient time provided, then it's sometimes possible to agree an extension for any response to be made, and where it's not possible, it might even be in their best interest just to make no response at all or to make a very limited response. There's also a 3-year time limit to bring a prosecution, so the pandemic's unlikely to prevent prosecutions from actually proceeding. All the CQC have to do is issue a summons to the provider within that 3-year time limit. So we expect to see a greater influx of these types of cases as things return to normal, and particularly now that inspections are beginning to take place, because standards will have undoubtedly slipped in some care services during this period. But we do still see a delay in hearing cases in magistrates' courts. Some are still not having face-to-face hearings, and some are just putting cases off. So it's likely to see these types of cases prolonged to an extent as well. If we go on to the next slide, I think the sector as a whole has been at the forefront of this pandemic, obviously, and so it's likely to come under even more scrutiny moving forwards. It's understandable that care home providers' priorities will have shifted during this time, and focus will have been more on keeping people safe and COVID-free as opposed to filling in documentation. But as I said, some management teams will have dealt with this better, and it's the ones that have struggled with juggling all of these different things where the risk is higher. Given that inspections have now recommenced and providers, they need to be prepared to manage the risk of any potential bad inspection or enforcement. So they need to be addressing any shortfalls now, possibly by getting an independent mock inspection or audit to identify these issues so they can address them before their inspection. And if concerns are raised, they need to be acting quickly to address those sooner rather than later. It'll also be advisable for them to have someone present to take detailed notes throughout an inspection, because this will help if they need to make any challenge against the report or the ratings. It's also important as well to maintain a good relationship with their inspector if they can, and to engage with them positively, providing them with documentation if requested, because ultimately it will be down to the inspector to make that first decision on whether enforcement should be taken. Providers shouldn't be anxious about challenging their inspection reports or the ratings. I think where they have solid grounds to do so, and they can back up any challenge with documentary evidence, then they need to do that. Inspectors expect to be challenged, and it's widely accepted that errors or mistakes can sometimes occur. That's why these processes exist. And I expect mistakes will happen, given that there will be a lot of pressure on the CQC to do a lot of inspections in a short space of time. From a risk management point of view, it's vital because it can make a difference between enforcement or not being taken. I think providers also need to consider taking specialist legal advice at all of the appropriate points. And if they need practical advice on how to achieve compliance, or they need support with making the changes, then a specialist care consultant can always be a great investment. Consultants are often invaluable in providing supporting documentation for any required legal challenge, and providing expert evidence in a court or tribunal as well. If they have identified issues either through a CQC inspection or prior to that, then they need to have a detailed action plan in place as well, with reasonable timescales, just to provide reassurances to the CQC about any shortfalls. But overall, preparation is usually the key to managing risk in line with CQC.